What I'd like to do today is focus on risk management, because not-for-profits in today's climate are subject to a whole variety of laws. Most not-for-profits generally are incorporated either under Ontario law or under federal law, and you might have chosen to incorporate federally because you have a national reach in terms of what you're doing. You also, if you're registered charities, are subject to the income tax regime because, as you know, to become a registered charity, you have to apply to Canada Revenue Agency to be registered, and you have to go through a whole review process by them, and you have to file an annual return with them, which tells them what you're doing with your charitable money, and they monitor all of that. And if you fall offside some of their rules, you could risk the consequence of losing your charitable status. So those rules are very important to you if you are a registered charity and you want to remain a registered charity. Overlaid on top of that, because you're all operating in Ontario, you have our Ontario law that governs charities, because charity law is provincial law. Now, your status as a registered charity through Canada Revenue Agency is based on federal income tax law, but any other aspect of charity law is Ontario law. So with all of that in mind, I'm going to leap into the first of the 5 good ideas, and it is to understand your mandate and do not stray from it. And why is that important? And first of all, where do you find your mandate? You find it in your letters patent. So if you've been incorporated in Ontario or federally, your letters patent sets out what you can do. And it literally has your objects right there in black and white. You may have expanded your objects at some point in time, and in order to do that, you apply for supplementary letters patent. So you may be in a situation where you have letters patent and supplementary letters patent. In addition, you have a set of bylaws. So what you can do can be found, first of all, in your letters patent, and how you do it is in your bylaw. So it's very important for any director or officer of a non-share capital corporation to know what their mandate is, to have reviewed the letters patent, to have reviewed the bylaw, and I think that should really go on possibly on an annual basis. And certainly for any new member of your board coming on, the first thing that they should be given are your letters patent and your bylaws, and they should be asked to review them. Now, why is it important to not stray from your mandate? Well, obviously you have a mandate, you've thought it through, and you've set it out in your letters patent. If you come up with a new program or some new activities that your board wants to pursue, or maybe your staff is coming to the board and saying, look, we've got some great initiatives we want to put in place, they should fit within your objects. And if they don't, the risk to the board is that if something bad happens as a result of pursuing that program or undertaking those activities, they could be personally liable because they have allowed something to be carried out that was not authorized. And just so you understand, in terms of corporate law, a business corporation, as distinct from a not-for-profit, a business corporation has full range of powers to do anything they want. So virtually nothing is outside their authority. But you, as not-for-profits, can only do what your letters patent allow. And anything that's outside of that is basically outside of the authority of your company to do. So it's a very important risk management technique to be aware of what you are authorized to do and make sure that what you are doing is authorized. The second one is decide whether you need directors and officers liability insurance. Now, the federal and provincial corporate law that you're incorporated under permits the company to indemnify its directors and officers for appropriate things, and also permits the company to purchase directors and officers liability insurance. You may need to look at your bylaw and make sure that your bylaw has also authorized those things. But if you're a charity in Ontario, the public guardian and trustee, and that is the official in Ontario whose mandate it is to supervise charitable activity in the province, the PGT historically took the position that using charitable funds to indemnify directors and officers or to purchase directors and officers liability insurance was not an appropriate use of charitable property. It was benefiting personally the directors, and there's been a long-standing trust principle that directors of charities are basically like trustees, and they're always to avoid any conflict of interest and never to prefer their own interests over the company. Well, you'd say to yourself, common sense tells you no one's going to volunteer to be on a board unless they've got directors and officers liability insurance. So there was a great deal of lobbying, and finally the PGT said, okay, you can go get a court order to allow you to do this. And we all said, well, that's not very helpful. How many little charities are going to run off, hire a lawyer, pay them to go to court and get an order that permits them to do what they really should be doing anyway? So eventually we got a regulation. It's an Ontario regulation that deals with purchasing directors and officers liability insurance or indemnifying your directors and officers. And it says it's okay to do this, and you'll be deemed to have obtained a court order allowing this as long as you stay within the parameters that are set out in the regulation. So it's very important to read that regulation. It's not long, it's a couple of pages, and I'm going to highlight some of the criteria that you need to consider in order to be deemed to have done this appropriately. So the first thing you're supposed to do is consider the degree of risk to which your director or officer is exposed to. And then you weigh that up in terms of the cost to the company to either indemnify or to purchase the directors and officers liability insurance. So there has to be a reasonable ratio. You have to say, look, there's serious risk here, and we need to protect our directors and officers from that risk. You need to obviously be able to justify the cost of the insurance that you've purchased, and you have to be able to justify any indemnity that you pay out. It's important that you look at your balance sheet and make sure that whatever you've spent to provide the indemnity or to purchase the insurance is reasonable in relation to the revenue and the assets that you have. It's also important to consider where the money's coming from. If you have endowments that you're holding, generally the PGT, the Public Guardian Trustee, takes the position that managing an endowment is very low risk activity and it doesn't require this kind of protection. So it's their view that you can't be dipping into endowment funds to pay for your directors and officers liability insurance. You have to find other places, other assets, other revenue to fund this expense. So as a final comment on this idea, I've pointed you to the primer for directors of not-for-profit corporations that's published by Industry Canada. It's on their website. It's a wonderful resource. I dip into it all the time, and they have a chapter that's devoted to this topic, and they go through all the kinds of insurance products that are out there, all the pros and cons in terms of which kind of coverage to obtain. So it's a really good resource if you're struggling with whether to get this kind of insurance, what kind of insurance policy to get. That's a great place to look. Be ready for the new not-for-profit legislation. And I don't know if you're aware, but the federal government has already introduced and passed into law a new Canada Not-for-Profit Corporations Act. It's not in effect yet because it's going to make such a huge change to the regime that federally incorporated not-for-profits are going to be subject to that they're giving you time to get used to it. I think by now the regulations are actually drafted and they may be available for review. I asked one of our corporate partners who's been very involved in the reform process when we could expect the federal statute to come into effect. He said, well, spring of 2011 at the earliest, possibly later next year. What happens there is that once it's actually in effect, you have 3 years to comply. On the Ontario front, we have the same reform going on. Both of those laws are very old, archaic corporate laws. They're very out of date. So Ontario went through the same reform process, and they passed the Ontario Not-for-Profit Corporations Act October 19th. It received third reading. I shouldn't say it was passed. It's still, it's got to be enacted. Right now, the Ontario regime is developing its own set of regulations that will be in effect under this new corporate statute. So the best guess we have is that fall of 2012, the Ontario law may be enacted, and then you again have 3 years from when it's enacted to bring yourself in compliance. The two regimes are very similar, but they're not identical. And unfortunately, they use different terminology. So under the federal law, There will be soliciting corporations and non-soliciting corporations. Under the Ontario law, they're going to be called public benefit corporations or non-public benefit corporations. But essentially, they're the same thing. So if you're a soliciting corporation or a public benefit corporation because you're in Ontario, you're essentially funding your activities through public money, either through donations that you issue a charitable receipt for or government grants. And the basic dollar threshold is $10,000. So if you are under $10,000 in terms of what you bring in from public money, then you are a non-soliciting corporation if you're federal, or a non-public benefit corporation if you're in Ontario. Most of you, probably all of you, are going to be considered public benefit corporations if you're in Ontario, because I'd be surprised if anyone could operate with less than $10,000. If you do, that's great, and you will be subject to less financial reporting obligations. I mean, the basic difference between these two categories is that if you receive more than $10,000 of public money, you're going to be required to be more financially transparent in terms of your operations. In the federal regime, the federal government requires you to actually post your financial statements on their website when this comes into effect. In Ontario, you don't have to do that, but where you're going to see the difference is in the audit requirement. So right now, actually this is going to be a little bit of a benefit to you. Right now, the rules are much stricter. Most federally incorporated or Ontario incorporated not-for-profits have to have their financial statements audited. There's some limited exceptions. They're fairly low dollar thresholds. Under the new regime, those thresholds are going to be higher. And so you'll probably find that you might be able to avoid an audit under the new rules. I'm not going to get into all the different dollar thresholds because they have 3 or 4 different thresholds that are relevant. And the biggest concern for you is if you haven't been auditing, haven't been having an audit of your financial statements, you'll want to know where you fit within the dollar thresholds, because if you're into a threshold where an audit is required, you're going to have to make sure you do that. There are other differences. Key difference will be in how members are treated under these new regimes. The approach that both the federal government and the Ontario government has taken is to make it more democratic for members to belong to not-for-profit organizations. They want to give members more rights. So our advice to clients is when this regime comes into place, you've got 3 years to get yourself in compliance. Make sure you look at your membership structure and make sure that the new rules are not going to create a problem for you. And I don't want to get into a huge amount of detail here, but I think the takeaway is be aware of when these regimes come into place. You still have time. They're not in place yet. And remember that you have 3 years from when they come into place to bring yourself in compliance. Another difference between federal and Ontario, under the federal regime, if you don't file articles of continuance under the new statute within 3 years of its enactment, you could be dissolved. Now that's pretty drastic. Nobody would want that to happen. In Ontario, they took a different approach. They said, no, we're not going to dissolve corporations, but we're going to deem you to have amended your letters patent and your bylaws to be in compliance. So then you're left with, okay, 3 years goes by, you didn't do anything. You now have a different set of constating documents that you don't even know what's in them, right? So my advice would be spend your time during that 3-year period to come up to speed on what this means for you. Make sure you do amend your own documents the way you want them to be amended, so they work for you the way they should. And then you're not facing these, on the one hand, on the federal side being dissolved, or on the Ontario side having a set of bylaws and what we'll now call articles of incorporation that are not appropriate for you. Be familiar with the new Canada Revenue Agency fundraising policy. They came out with the new policy on fundraising in June of 2009. I think I've given you the sites in the resource materials. It's on their website. For some strange reason, they've got 2 different documents posted on their website. They're different documents, and you have to flip between the 2. If you view them on screen, there's links between the 2 that take you back and forth. But if you print them and try and read them, it's a little bit difficult. So I just give you that little caution. the important thing I wanted to just highlight today is that with the March federal budget, which did away with the disbursement quota rules that we used to have for charities, these new fundraising guidelines are going to become very important. I mean, basically the disbursement quota from now on is going to be, you must use all your charitable resources to carry out your charitable activities, and if you're holding investment funds, like you have an endowment fund, you have to disperse at least 3.5% of those endowment funds to meet your disbursement quota. Why is fundraising important? Because people spend money fundraising, and it's the CRA view that fundraising expenses are not charitable expenditures. So you have to make sure your fundraising policy is such that you keep your expenses for fundraising as low as possible. They have set out what they consider to be reasonable ratio of costs versus revenue. So if your organization spends less than 35% to raise, let's say we're talking about $100 of fundraising revenue. If you spend less than $35 to raise your $100, you're okay. You can be comfortable that you're not going to be attracting any scrutiny. If you're between 35% and who knows what, some upper limit, then there's a possibility that CRA might take a look at you and might want to ask you questions about this. If you're over 70%, you are in the danger zone, and you have to make sure you get down. So I definitely recommend that you look at this policy that they've published. They list what they consider are best practices, and you may all be doing these things already. Basic things like develop a fundraising policy. Make sure anyone who's working for you to do fundraising has read and understands the policy. Give them a funding script. Make sure that the message you're giving to your donors is consistent. Monitor your receipting process. If you're a registered charity and you're issuing a receipt to a donor, make sure that your staff understand all the ins and outs of issuing a receipt. And then periodically evaluate your fundraising activity and make sure it's appropriate, you're within the right cost ratio. And use volunteers to the greatest extent possible. I mean, this is the key message that CRA is sending out to us, is that they feel that if you have volunteer staff that can do the fundraising, that's what you should be doing. And where this, their fundraising concern really came from a lot of press where charities had hired commission people to raise donations, or they were paying exorbitant amounts to third-party contractors, and they felt that it was a waste of charitable money to be spending this kind of money fundraising, especially because fundraising in and of itself is not a charitable activity. So I'll just leave you with the thought that you want to know what their policy is, make sure you're adhering to it. Be familiar with the parameters of legitimate political advocacy for your charity. So first of all, I should say that if you are not a charity, and I'm not sure how many of you here are not charities, because obviously you can be a not-for-profit organization and not have registered with CRA as a charity. In that case, you can do all the political advocacy you want. There's no restrictions. This concern around political advocacy is only for charities. And the basic principle is that charities are permitted to engage in political activities only if it furthers your charitable purposes. That seems like common sense. You're also subject to certain prescribed limits as to how much of your resources you can spend on political activities. And I'll talk about what those limits are. And there's certain political activities that are absolutely prohibited for charities. So I'll start with those. The prohibited activities are any direct or indirect support or opposition to a particular candidate or a particular political party. So a charity is not allowed to go out and campaign either for or against a particular candidate for political office, nor are they allowed to advocate that people join the Green Party or the whatever party. That is prohibited. So your political activities are supposed to be nonpartisan. They're supposed to be directed to furthering your own charitable goals, and you are to keep yourself within certain dollar limits, and I'll now talk about those. So a charity that has less than $50,000 of annual revenue is allowed to spend up to 20% on political activities that further their own charitable goals. If you're between 50,000 and 100,000 of revenue, that percentage goes down to 15%. If you're between 100,000 and 200,000, you're down to 12%. And if you're over $200,000, you must limit your expenditures to 10% of your revenue. What gets tricky is what is an expenditure related to a political activity. And I think the best thing I can tell you is to go to the policy document that I've referenced for you and read through it, because it's a gray area and CRA has their views. They may not necessarily be reasonable views, but you at least want to know what they are. And the other thing to understand about these CRA documents that I'm pointing you towards is they're not the law. They're what CRA thinks is the law. So there's a bit of latitude here, I would say. I mean, use your common sense. I mean, really, they come out with policy documents all the time, and they make these pronouncements. Some of them eventually get tested in the courts, and they're not always found to be accurate. So I just would say to you, take it with a bit of a grain of salt, but I think you'll find when you look at the fundraising document and the political activities document, it's mostly common sense. And most of it is something you'd certainly want to be aware of and be in compliance with.